The first thing I want to talk about is, two keys to one of the keys to employment is at-will employment, but there's another term called right to work, and a lot of people get those two terms confused, and they're completely different concepts. And I even see lawyers that claim to be knowledgeable in this field. They also do not recognize the difference in these terms and use them at times improperly. And so right to work is a different concept, and it really deals with whether the state is a right to work state or not. And Texas is a right to work state, and some are and some aren't. But what that means is if you're a right to work state, you have a right to work even if a union comes in and tries to unionize the workforce and successfully unionizes a workforce at a particular employer. You do not have to join the union to continue to work for that employer because Texas has a right to work state. If they didn't have a right to work state, you would have to join the union or stop your employment with that company. And so that is what right to work means, and it is a completely different concept than at-will employment. Texas is also an at-will employment state, and that's what mainly this class is going to be talking about. 80% of the time, at-will employment is going to be coming up. And why it does is this whole class is about exceptions to at-will employment. So the basic standard of at-will employment means that the employee or the employer can end the relationship at any time, with or without cause, with or without notice, for no and except for as prohibited by law. And so the employee can quit at any time and leave, whichever one understands, and the employer can fire you for any time as well, as long as it's not for an illegal reason. It could be no reason or even a bad reason that's not fair, but fairness is not the test as long as it's not an illegal reason. And what this class is we will talk about is going to be the exceptions to at-will employment. And when you have an exception to at-will employment, it prohibits the employer from terminating in certain circumstances. So this last phrase here, except as prohibited by law, that is this whole class, and that is a very important part of this definition. And if someone asks you to define at-will employment and you left that part out, you're missing the entire concept, because you are an at-will employee and at-will employment, but you can't just terminate at any time for any reason. It's any reason prohibited except as prohibited by law. As we look at this slide here, there's exceptions to at-will employment doctrine, including and some of the exceptions to it, and these are all pretty much statutorily imposed. There's a few public policy reasons, but like harassment and discrimination, you cannot fire someone that would be in violation of one of those statutes. With respect to retaliation, if someone makes a complaint under one of those statutes, you could not terminate them, because once you complain under a statute, you're given additional rights as basically a complainer, and then the law provides under the statutes that you cannot be terminated. So that would be an exception to at-will employment. Refusal due to do an illegal act. Your employer can't tell you to violate some environmental law or drive a truck without proper inspection, and if you refuse to do so, you would be protected from being terminated for doing that. Now, if you actually drove the truck, then you performed the illegal act, and then you complaining about that may or may not give you a cause of action. Another reason that would take you outside of at-will employment is an employment contract, and that would be you're negotiating the employee is negotiating with the employer for possibly a for-cause termination situation, and if they do that, then the contractual provision is taking themselves outside of at-will employment. Pretty much Only high-level executives are enter into employment contracts with employers. And if you think about coaches at universities, these football coaches and things like that, they'll have multiple year contracts, and that gets a lot of news when someone gets fired. Recently, the coach of A&M, Jimbo Fisher, got fired, and the buyout of his contract was, over $70 million. And so the reason why they couldn't terminate him in an at-will capacity is because there was a contractual restriction there. With respect to a member of a union, if you're a union employee, then you're going to be subject to a collective bargaining agreement. That's another form of a contract between the union and the employer, and that would take a person outside of at-will employment. Other examples that aren't on this slide would be taking certain kind of leaves under USERRA, which is the Uniform Service Reemployment Act, and the Family Medical Leave Act. If someone took a leave under that, you can't terminate someone for taking a leave. Thus, that would be another exception to at-will employment. And then there's numerous other statutes that prohibit people from being terminated due to them exercising a right under that statute. And what's important is a lot of the laws that provide these exceptions are state laws, and each state will have its own unique laws that would preclude someone from being terminated from employment. Another example is New York State has a law that says you cannot terminate someone for engaging in off-duty conduct that's otherwise lawful. So if they're engaging in some kind of protest or some kind of political speech or doing some kind of activity in New York, marijuana is legal, and if you terminated him for that, then that would be something that would be an exception at will employment there, as long as they were doing that not at work, that activity not at work, because you can control that, but you can't control it while they're off-duty conduct. And that would be an example of a state law and that would limit at-will employment. So you need to be cognizant of that, because those will vary from state to state. And that is consistent with the book talking about the employment law being the sources of employment law being fragmented, because they come from various areas, and each state has its own laws that would affect this. Moving on to who is an employee, the definition of who is an employee is an important concept too. The definitions are not very thorough, or they're not very helpful, is a better way to say it. Instead, they are a person who permits or suffers is someone who is an employee, and that's how it's defined in some of the statutes. Or another statute is a person employed by an employer. Again, not very helpful. And so what types of employees are individuals or workers who are employees or who aren't employees is not very obvious in certain circumstances, and other times it's very obvious. And so there's different tests that are applied, and we'll talk about those. The book talks about those, and you have to recognize that it's not always the same test. Different statutes and different agencies use different tests to determine who is an employee and who is not. And so it's not one test fits all situations, which makes it a little more complicated than it should be, as well as it's pretty gray under certain factual situations. Here are some examples of people who are not employees, and that would be someone who's an independent contractor. And we'll talk about that in a few minutes, about the test that would apply to people who are independent contractors versus employees. Owners of businesses, that's another person who's not an employee. They're the actual owner of the business, and they would not be protected by some of these statutes. Partners, in a law firm or partners in a medical practice or some other kind of professional practice, it's a partnership. The actual partners who own a part of the business, they are not considered employees. Interns who are there to learn, who may be getting some kind of college credit or some other kind of thing that's more for their personal benefit, they would possibly not be employees. There are some interns, depending on what they do, that definitely would be considered an employee under those circumstances. And then lastly, or not lastly, but volunteers is another group that if they're truly a volunteer, someone that works for the Red Cross on the weekends, or someone who possibly is a volunteer fire department employee in a small community or something like that, or if you go volunteer for Habitat for Humanity, that would not be considered in most circumstances an employment relationship. And then contingent workers, and what this is talking about here is they're definitely an employee. The question is, who are they an employee of? Are they an employee of the staffing agency, or are they an employee of the actual company where they have now been sent to perform services? Who's technically their employer? And a lot of times they can be joint employment there, but that's really the test. There's who is the employer, not who is the employee, because they would be an employee of someone, but could be both. And why this matters is because it determines what laws apply. If you're an employee, you're going to be entitled to certain protections, and non-employees are not going to be entitled to the protections. So all the exceptions that we were talking about to at-will employment, those would be exceptions that an employee could say, look, you fired me for one of those exceptions for which you were prohibited from doing so, and they would have a cause of action or a right there. Whereas an independent contractor or a partner who tried to sue for one of those statutes would not be able to do so, because they are not an employee, and you have to be an employee to be entitled to relief under those statutes and be protected by them. As I just kind of highlighted, why does it matter if you're an employee or not? Because there's a lot of benefits that come with that, and that's the statutes I was talking about, the federal statutes, the state statutes, and the common law by each state that's been put in place to protect employees. And those would be essentially the exceptions to at-will employment. Also, if you're an employee, and I assume a lot of y'all have held a job before as an employee, when you get your paycheck, if you'll notice, there's a lot of withholdings from that. And the government withholds certain taxes, and the employer has to pay certain taxes on your behalf when you're an employee. And what are those? Those are basically unemployment, Social Security, workers' compensation, and those are by really insurance policies to provide employees certain benefits. But an independent contractor can't claim for unemployment. They can't claim for Social Security, because those are not those are only available to someone who was an employee and then lost their job or got injured. If you're in a union versus a non-union, you are an employee, but you have certain rights there. Union employees can only be terminated for cause after due process. So you have to give them due process, and then based on the due process, if it comes out that you can terminate them for cause, you can terminate them. A non-union employee would be an at-will employee and could be terminated for any reason except as prohibited by law. And for instance, you may have heard of, like in the Major League Baseball, MLB, those players are part of a union contract. And if you violate one of the drug policies of the MLB, you get suspended. I don't know exactly what it is, but the first one is like a 20-game suspension, and that could be off. And the next one would be maybe a 60-game suspension. And then the last one is you're banned from the league for a year or so. And those are probably, I know those are just guesses, but it would work something like that. And whereas if they were an at-will employee and they violated the drug policy once, you could just fire them, but they've negotiated for that. So what we're paying attention to here is if they're an employee, what type of employee they are, because depending if they're a union employee or a non-union employee, it depends on whether they're at will. And at will is associated with non-union employees, and union employees, it's associated with just cause and due process. And another example of that is when you hear that a school teacher or some kind of law enforcement has had an inappropriate relationship with a student and or someone they've arrested, and you're always like, well, why are they suspended pending further investigation? Why don't they just fire them? They can't fire them because they're part of the union and they have to go through the process and investigate it and before they can fire them, because they have to show they have given them due process and fired them for cause, because they're not at-will employees. They will eventually be fired, but when the report first breaks, it always says they're on leave, and why that is because they're union employees and not at-will employees. It can't be terminated immediately until they go through the proper process. And then lastly, public versus private. What that is referring to is a government job versus a private job. And so if you work for the government, a fire department, police department, or the actual government, you're considered a public employee. And if you work for a private company, then that's considered a non-public employee. And this is not the same distinction of an Exxon. An Exxon or Amazon, that would be a private employee. It's not talking about people that are private, that are publicly traded on the stock exchange. It's not talking about public companies. Those would still be private entities. This is talking about a government versus a non-government, is what the use of these terms public versus private means. And what's important there is the private employers typically are going to be all at-will employees unless there's a union involved. The public are almost all unionized employees, and they have a property right in theirs, and they can't be terminated as, quote, an at-will employee and have to go through the just cause and due process procedure that we talked about with union employees. Okay, independent contractor misclassification. This is really where you're going to come in and determine how someone is an employee or an independent contractor. And the federal government is really it wants to classify people as employees. And why would they want to classify them as employees? Because they're missing out on taxes. An independent contractor doesn't have taxes withheld from his or her paycheck, whereas an employee does. And so the government doesn't like when people are misclassified as independent contractors versus employees, because they have to then depend on the independent contractor to file and pay their taxes down the road versus being immediately withheld from the paychecks. And because of that, there's been this big push, and plaintiffs' lawyers understand this, and so they go in and try to say, look, you misclassified someone as an independent contractor, they're truly an employee. Now, this typically will happen when it won't happen when the person is working for you and providing services, because they love being paid as an independent contractor. And the reason why is because there is no taxes being withheld. But once the relationship ends, they will come in, there's no safety net, there's no unemployment, there's not anything if they get hurt, they can't file under workers' comp, because all those are for employees, or if they feel like they've been discriminated against. Those statutes do not protect them. So once the relationships end, oftentimes those people come in and say, hey, you misclassified me as an employee, as an independent contractor and I was truly an employee. And why they want to do that is they want to take advantage of some of the protections that are provided by the statutes if someone is in fact an employee. If you are an employer and you're kind of deciding whether to classify someone as an employee versus an independent contractor, it's always less risky to, if you can't really tell the difference based on the test we're about to go through, it's less risky and it's more conservative to go ahead and classify them as an employee, because then if you comply with those kind of laws, no one ever really comes in and challenges and says, you misclassified me as an employee, I should have been an independent contractor. I mean, those cases are pretty much non-existent. The test, as I said earlier, there's different tests for different things, and to determine all that. Like there's a different test for interns, there's a different test for independent contractors, and different statutes. So here are three tests that talked about in the book. There's the IRS test, and it basically, and these may not be in the book specifically, but these are tests that apply. And so if you don't see one of these in the book, these concepts are there. But the IRS test is a test. If you look on the IRS website, at times it's been as much as 20 factors, and at other times, they'll take a few factors off or not. And that's to determine under the IRS whether they're an employee or not, and whether you should be withholding taxes. The economics realities test is a test that's typically used under a statute called the Fair Labor Standards Act, and it's whether to determine if someone is an employee or an independent contractor. And if you look here, there's 5 factors, and these factors really deal with, does it look like the person's in business for themselves, or does it look like they're doing the business of the company for whom they're providing services? And so the degree of control between the company, the relative investment, have they bought a truck, have they bought their tools, or are those being provided by the company for whom they're providing services? Did you give them a computer? Did the company give them a computer? Did they give them an office? All that would look more like an employee. Opportunity for profit and loss. Employees typically don't have the ability to profit and loss from a thing, whereas an independent contractor, they bid the project wrong. If they're going to build your fence and don't realize that there's a lot of rock underneath there, it may take them longer to do the holes and do that, and so they could lose money themselves if they did not do that. That independent contractor fence builder would also have typically their own tools, their own nail guns and things like that, which would also look like they're in business for themselves. They may advertise by putting flyers around neighborhoods. We build fences. That looks more like a true independent contractor. Now, if you build fences, but you only build fences for one particular home builder nonstop, then you would probably be an employee because they're directing all of your work. And then the permanency of the relationship, and that kind of goes into that example I just talked about. If you're building a fence for one neighbor and then someone 5 blocks away versus one home builder for every new house they build, that relationship for the latter would be a lot more permanent and would tend to show that they're an employee versus an independent contractor. And then under some of the discrimination laws, they have what's called a common law test, and it really focuses, it has its own factors, and those focus mainly on control. But the point of this slide is there's different tests that will be applied when you're reading the cases in the casebook, in the textbook. Sometimes, if you're wondering why does a certain test apply at certain times, it's because of the statute that's being employed in that time, or how that jurisdiction has come up with common law to define who is an employee or an independent contractor, or an intern versus an employee, or volunteer versus an employee. All those have different tests. Getting back to at-will employment, and I want to kind of end with that as we are getting there. At-will employment again, this class and what we've seen is people want to be employees at times when they want to assert rights. They don't like to be employees when you're withholding taxes. And so, again, that at-will employment definition, which this whole class is based on, and you have to be an employee to fall within this definition, is the employee or the employer can end the relationship at any time, with or without cause, with or without advance notice, for good reason, bad reason, or no reason at all. And then you see the text here that's highlighted in bold and in italicized, except as prohibited by law. That's what we'll be talking about in this class. And it's those exceptions that then prevent the employer from doing that. And that is the most important part of that definition, or it's as much as it's as important as the beginning part. And if you'll look on page 14 and 15 of the text in figure 1.1, you'll see that the exceptions that have come into put in place over the history kind of track what things that have been going on in society over the years. And if you look at the laws that become the exceptions, and there's more than that's right here, but this in this chart, but it's I think it's helpful and kind of interesting to look at. If you look in the 1920s or really 1930s under the 1920 heading, what was going on there was the Great Depression. And during the Great Depression, they needed more, they introduced Social Security, and they introduced the Fair Labor Standards Act, which required employers to pay overtime to try to get more employees in the workforce, and because of the need to do that, because there were so many people that didn't have jobs. In the 1960s, you had Title VII, the Equal Pay Act, which was equal pay between men and women, Executive Order 11246, which dealt with affirmative action. And so during the civil rights is when all the discrimination and anti-harassment and discrimination statutes were put in place. And then in the 80s, there was big layoffs and downturns, and that's when you've probably heard of COBRA. It got put in place in 85. And the Warren Act, Worker Adjustment, Retraining, and Notification Act of 1988, is all because of the economic hardship that was going on in the 1980s. If you'll notice here, the ADA, it was just put in place in 1990, and people think, well, people now just think that's been around forever, and it really hasn't. They noticed the need in the 1990s to protect those. Also in the 1990s, the Uniformed Services Employment and Reemployment Rights Act got put in place, and that's because of the Gulf War that was going on there, and people were coming back from the Gulf War and didn't have jobs, and so they put that in place. HIPAA. You've heard of HIPAA, I'm sure, by now, and it's to protect health information. What happened in 1996? That's when the boom of all the Yahoos and Google, well, not Google, but Yahoos and AOL.com took place, and all the electronic records and emails started going in. They had to put that in place to protect these electronic records because they were now more subject to change than ever. And then as we move into the 2000s, with more information in genetic testing, they had to put laws to protect those folks. And this continues on. And I think 2018, they had some case law and amended the statutes to protect, people of different sexual genders and things like that under the statutes. So as you can see, these protected classes continue to change over time and will continue to change as we go forward based on societal issues. And so that concludes this lecture. Thank you for your time and attention, and we will talk to you as we move through the class and do a few other lectures. Thank you.